Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós, uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
So, good morning, or better, good afternoon, everybody. Good afternoon, ladies and gentlemen, dear colleagues, dear students. Welcome back, Professor Gautier, to the second part of this lesson. It's a pleasure to have again here Professor Philippe Gautier in this course. Thank you again for your availability. And we have today the second part of his presentation about the ICJ and the settlement of international disputes, new challenges. As I mentioned, it's a pleasure and an honor, Professor Gautier, have you here. I think the floor is yours. Thank you very much.
Thank you very much, Professor Marcio Franca. It's a pleasure to be again with you, your colleagues and the students of Belo Horizonte. And good afternoon, all of you. I think now it's 1 past noon. We will continue what I had introduced to you last Monday on the activities of the ICJ, and last Monday I concentrated my presentation on the peaceful settlement of international disputes as a principle, and I already gave you an introduction to the ICJ. It means composition, competence, functioning, or basic functioning. Just today, I will concentrate on two aspects of the activities of the court. And first, I will touch upon a few recent trends and new challenges in the work of the ICJ. And second, I will make a few comments on the contribution of the court jurisprudence to the development of international law. That's also in order to show the evolution of the court and its impact on international law. Just first of all, I would like to address what I called recent trends and challenge. I am trying to share with you a screen and a slide with a PowerPoint presentation. I hope it's visible for all of you. And in order to address this, what I call recent trends and new challenges, I will start with some statistical data. It's always interesting in order to give an overview and to indicate trends. And I will first address the number of cases and also the parties involved in proceedings before the court. As you see on the slide, between 46 and today, 178 cases were introduced, 151 contentious proceedings, and 27 advisory proceedings. If you want to look at the output, it means the decisions which have been delivered, there are 133 judgments and 28 advisory opinions and 600 orders concerning both procedural and substantive matters. It doesn't coincide, you will tell me, but simply because sometimes, a case will not go until the end. Parties may agree, or they may withdraw, or cases may be joined together. There may be a variation. I mentioned 28 advisory opinions. It means simply that for one advisory proceeding, there were 2 advisory opinions. And that would be a good question during an exam. What is the advisory proceeding concern? That's the peace treaty. That's one of the early cases before the court. It's important to keep that in mind, 178. It's a relatively modest number if you compare that with thousands of cases before regional court, human rights court, especially the European Court of Human Rights. But you need to consider that here we are speaking about interstate litigation. It's quite different. If you compare to similar courts, even international arbitration, it's a very high number. And I underline that because in the current period where there is sometimes a lack of confidence in multilateralism or in international institutions, the ICJ as the principal judicial organ of the UN is successful when you look at the number of cases. Of course, you need always to be modest in the sense that nothing is to be taken for granted. I've already used this expression 2 days ago, but you know that the court was not always so busy. If you consider the period after the 66 decision in the Southwest Africa case initiated by Ethiopia, Liberia, first the court considered itself that it could be competent, but after that in 66 declared that there was no actio popularis, that the mandate on Namibia would not allow member states of the UN to bring the matter to a court. After that, during 3-4 years, there was no new case. I mentioned that just to underline that the situation is completely different now, and I will explain that to you. But you need always to be vigilant and to deliver. If you look at this number of cases, what is interesting to mention is also that only 40% of it, 62, were initiated during the first 45 years of existence of the court, between 46 and 90. Thus the large majority, 89, has been filed after 90, in the 90s and after, and in 2000, the next millennium, the current one. Because that's important to see that there is really an increase in the trust which is given to the court in settling disputes. There is a need. The court responds to a need. That's what I would like to stress. In the 90s, there were 35 cases instituted. In 2000 plus until today, 54 cases. There is really a number of cases which have been instituted, and for the time being, there are 2, 3, 4 cases a year which are filed. I have to say, figures may always be taken with some cautious approach. I know you will tell me that one incident led to 9 different cases. That was Serbia, Montenegro at that time, instituting 9 proceedings against NATO member states after the Kosovo crisis. But even if you take into account this episode, the average and the number of cases is quite good. Of course, it means that there is a responsibility on the court to deliver. And that's the challenge we are faced with today, especially in time of pandemic situation. The court cannot stop functioning, and there is a need to deal with parallel proceedings at the same time. Usually, there are 2 proceedings dealt with at the same time, and the objective for the time being is to deal with more or less 4 cases per year, perhaps plus, but that's the reasonable approach. But it puts, of course, heavy burden on the court and on its registry. You will see that in 2019, the court delivered 3 judgments in contentious proceedings, 1 advisory proceeding, and in previous years, we were also meeting this yardstick. It means 3 to 4 decisions per year. It's not so easy, but it's the rhythm which has been followed so far. So far in 2020, but we had some delay with the Corona crisis, but there was an order on provisional measures, an important one in the Gambia versus Myanmar, and 2 judgments in ICAO cases. That's the first point. As regards the parties, it's interesting to note that the geographical distribution of parties has modified over the period of time, and you may know that nowadays, it reflects the true universal character of the court jurisdiction. If you are interested in figures, until today, 101 states have been parties to contentious cases before the court. There are 193 states member of the UN so far. That gives you things in perspective. If you look at states which intervene during advisory proceedings, not contentious, advisory proceedings, there were 126. That also is interesting to note. During the first years of existence of the court, the first 15 years, most litigants or those instituting proceedings were from Europe, European countries, Canada, and the United States. But nowadays, as I indicated, the parties are coming from all regions of the world. And what is interesting to note is also an evolution in the sense that cases may oppose not only states from the same region, which is typical when you are addressing border issues, territorial, maritime delimitation issues. You have more and more cases involving states from different regions, like the Gambia versus Myanmar on the Genocide Convention, a case I have already referred to. If you look at the current caseload, 15 cases, you will see that 5 of them are mixed case, I mean cases involving states from different regions. For the 10 others involve 5 from Latin American and Caribbean group, 2 states from the Eastern Europe group, 2 from the African group, and 1 from the Asia Pacific group. That's the current configuration. If you put things into perspective, I will complete my presentation of the parties on that note. You will see also there is a variation if you take into account those states which are instituting disputes before the court. The states from Latin American and Caribbean group and African group, the number is relatively stable. And if you look at Latin American and Caribbean group, of course, or more precisely, Latin American countries, the Pact of Bogota is a stable source of jurisdiction for the court. If you look at cases brought by states from the Asian and Pacific group, you will see that for the period 2010 to 2019, the cases brought by the states of this region are nearly half of it. That's interesting to note, because sometimes it is said that it's not really part of Asian culture to bring a case before an international court. It means that things may change. On the other hand, cases brought by states from Eastern European group and Western European and others, those cases have decreased in recent years. I mean, brought to the court by those states. That was my second point. I would like now to address another issue, that's the subject matter of disputes, and to mention that there is a huge diversity of legal matters concerned brought before the court, and that reflects basically the broad jurisdiction of the court. Whatever dispute may arise may be, with the consent of states, be brought before the court. But I will here only concentrate on the current caseload, the 15 cases on the docket, simply because it represents truly a snapshot, really, of cases which represent concerns of the international community or the members of the international community. If you look at the current caseload, you will see that still the bread and butter of international jurisdictions, that's still delimitation issues. There are 5 cases involving territorial sovereignty or maritime delimitation. It's a stable figure. There are always issues relating to sovereignty of states, and that's something you need to be aware of. After that, you have 3 cases involving human rights, humanitarian law issues involving alleged breach of the Convention on the Prevention of Genocide, protection of human rights. That's 3 cases relating thereto. You have also 2 cases on sanctions and state responsibility for alleged breach of a bilateral treaty. You have international environmental law, 2 cases. We have still Gapsikovo, Najima Ross on the docket, but you have a case between Chile and Bolivia on the use of international watercourse. The law of immunities, diplomatic and consular relations, 2 cases, and use of force or the aftermath of use of force, 1 case. That's the case between DRC, Democratic Republic of the Congo, and Uganda. As you see, it gives you already a pretty good understanding of issues which are common to a large number of members of the international community. 4th point I would like to make is the increase of incidental proceedings. Of course, when we have a case on the merits submitted to the court is called upon settling a precise question, whether an obligation has not been complied with, whether there was a breach of that obligation. That's self-evident. But if you look at proceedings, you will see that there may be quite a number of what I would say incident. And here in front of you on the slide, you see those incidental proceedings in the order they are presented in the rules of the court. You may at a certain time ask provisional measures to the court if there is a risk to your rights and you need urgent action from the court. It's interesting to note that out of 151 cases, in 50 cases there were provisional measures sought. It means that's very often used, and it means that it also meets the needs of the states. It means also that whenever there is such a request to order or to prescribe, indicate in the case of the court that the court indicates provisional measures, in such instance, it means that there would normally be a hearing organized. That's a new process, or there are new proceedings within proceedings to be organized. And there is a decision to be reached. The same for preliminary objection. Whenever a state is arguing that the court has no jurisdiction, or that the claim is not admissible, or for any other reason which should be decided by the court in limine litis, proceedings on the merits are suspended. And it means that during 1 year or a bit more, the court will have to deal with those preliminary objections to see whether it can go on and address the subject on the merits. I would say that's the most important incidental proceedings which will have an impact on the way the case will develop and on the time spent on the case. Especially preliminary objections will take, as I say, 1 or 2 days. There will be a memorial, counter memorial. The other incidental proceedings, I will not dwell upon that. I will not address that in too much detail. Counterclaim, it's simply that the respondent will bring a claim in response, and the claim needs to be connected with the claim proper, which is submitted by the applicant. But that requires a decision also of the court. In all those, proceedings, there should be a decision of the court. Intervention. A third party may intervene if its interest is at stake or if it is party to a treaty which form the basis of the claim. Intervention will require also the court to deal with such a request and to see whether it's admissible. Discontinuance, that's easier because that means that states will decide that there is no need to continue proceedings before the court. They reach an agreement, for example, but it has also to be acted. Non-appearance, I mentioned that it's not an incidental proceedings, it's more an incident during proceedings. It's just to mention that it will also require the court to act, but non-appearance is not a bar to the court jurisdiction. I mentioned that because, those proceedings, and I will refer in particular to provisional measures, requests or preliminary objections, are quite frequent, as I've mentioned. If you look, for example, at the year 2018, there were 6 cases introduced through unilateral application, and for each of those 6 cases, there were issues of jurisdiction. That is a common feature. And if you look at the year 2019, the court had organized 6 hearings, but 3 of them involved incidental proceedings. 1 preliminary objection and 2 for request for the indication of provisional measures of protection. That has an impact on the ability of the court to address more cases, but so far the court was able to deal with those incidental proceedings in a swift manner. There was another point I wanted to address with you, and it's the last point I wanted to deal with while addressing this first part, the recent trend, new challenges. That's the complexity of cases. Before doing that, I will just move to further slides. Those slides will be sent to you. I had no time really to comment on that, but they are part of the background of this presentation. I try to move to another one. You bear with me. There is a problem of a technical issue, but we will come into Voilà. Okay, thank you for your understanding. I detected there was a problem with one of the slides and it blocked the whole process, but I will make sure that this is fixed when the set of slides is sent to you. Well, the last point, as I indicated, related to the so-called complexity of cases. And you may realize that in a number of cases submitted to the court, there may be technical, scientific issues which require expert opinion in order to deal with facts and figures and data which are submitted to the court. It may concern maritime delimitation, it may concern environmental issues, like the potential harmful effect of the construction of a plan in the border area. And therefore, it may be important for parties to call witnesses, or in this particular instance, experts, in presenting some evidence in support of their contention. That's a trend, I would say. If you look at the overall history of the court, there were expert or witnesses presented in 14 cases. But if you look at the recent history, the past 5 years, you will note that experts have been appointed by the parties in 3 instances. And in the case on the merits, they were joined. The case between Nicaragua, Costa Rica, and Costa Rica versus Nicaragua. The case concerning the construction of a road in Costa Rica along the San Juan River, and the case concerning certain activities carried out by Nicaragua in the border area. There were quite a number of experts, and findings of experts were analyzed by the court to assess the evidence submitted to it by the parties. And in order to assess the impact of activities carried out by one state on the territory of the other state. And on another part of the case concerning certain activities, when it came to the issue of environmental damage to the environment proper as such, a very novel notion, there also the court examined carefully the report, the expert report submitted by the parties to determine the existence and extent valuation of the damage caused to the environment. This recently, that's important to note, the court relied on and referred to the expert reports in those cases. What should also be mentioned is that according to the rules of the court, and it refers to the provisions in the statute, Article 50, for example, of the statute, the court may also decide itself, after consulting the party or hearing the parties, according to Article 67 of the rules, decide to appoint an individual, an expert, to carry out an inquiry and submit an expert opinion. Because that's a procedure which is in the hands of the court. And in order to do so, of course, the court will assess whether there is a need for such expert opinion. In most instances, you will tell me, parties have submitted a number of documents. They will submit exhaustive documentation, and therefore there is no need to designate, there is no need for the court itself to appoint its own experts. But it may happen. Until recently, the court had the opportunity, at the occasion of designating experts in 3 instances only. Twice in the context of the Corfu Channel case. It means the very first case submitted to the court in 46, the case opposing UK and Albania, and during the merits phase and also the phase relating to compensation, their experts were designated, appointed, and a third instance was in the Gulf of Maine, delimitation case between Canada and United States of America. That's the three only instances. But recently, in connection with the judgment of the court delivered on the 2nd February 2018, in the case between Costa Rica and Nicaragua, a case relating to maritime delimitation, more specifically the case concerning the maritime delimitation in the Caribbean Sea and the Pacific Ocean. There, the court decided by an order in 2016 to appoint 2 experts in order to assess a specific issue. It was not to bring advice or an expert opinion to the court on all points of delimitation. No, not at all. It's on a very specific item. That's the starting point of the maritime boundary. Because in order to draw a line into the sea, you need first to define from which point this line will start. And in this particular instance, given the configuration of the coast and the fact that there was some movement, it was not so easy to assess the starting point. And there, 2 experts were designated in order to fix this starting point. It's interesting to know, and for those who are interested, please have a look into the decision, the judgment of 2018. You will see that the nomination was not really challenged, and the expert opinion was relied upon by the court. Of course, whenever there is such an expert opinion, it's communicated to the parties, and the parties may have an opportunity to comment on that. But that's something which happened recently. I think it's important to mention that, and it may be also the beginning of a process whereby the court is more flexible in having recourse to experts. Of course, the challenging part of it, when you refer to complexity of case, is that that has a consequence on the length of the oral and written proceedings, also the deliberation of the court, when a case is more complex, when also there are incidental proceedings, as I indicated, the time spent by the court in addressing a case will be longer. That will create a burden, if I may use this word, on the registry, because it means it will be translated into a higher number of pages. To give you an example, in 2013, there were on the average 561 documents submitted in an annex to the pleadings. In 2018, those documents were more than 3,000. And it means more pages, but I mean simply the number of documents. 3,000 or 2,500 in 2019. This, you will have thousands of pages to be translated. It means also that from the side of the registry, we need to analyze and assess what needs really to be translated, because you cannot translate 10,000s of pages so easily. This also, the court has adjusted its practice direction. You will see, consulting the website of the court, that whenever there is a pleading, parties are required to concentrate on issues which are still dividing the parties, and not to attach whatever document may be found as an annex to the pleadings. Those should be relevant documents. Well, with a bit more than 30 minutes, I gave you an overview of recent trends, new challenges. Now, what I would like to do in also more or less 30 minutes to give you also the time to ask questions. Thereafter is to look into the contribution of the ICJ or its jurisprudence to the development of international law. And here I would like to make 4 points. You will see it's not the typical approach. I have just, for the 2 first points, focus on just a notion, predictability. What does it mean? We will see that in a moment. And also efficiency. And here I was more interested in the possibility for a court to deliver decisions whenever there is urgency to be able to render justice. And I refer to this motto, to this say, justice delayed, justice denied. Is that also something I would like to examine with you? Otherwise, new from among the issues which are submitted to the court, I would say human rights are part of it, definitively. And environmental law is something which has been accompanying the court, but recently there were a number of cases which may be interesting to refer to. Because that's the menu for the second part of this lecture. And when I refer to predictability, I should be very clear and cautious in the sense that it doesn't mean that when you bring a matter before the court, you know already the decision which will be rendered. That's not the way a court is functioning. It's not what I had and I have in mind. It's rather to offer to parties and to lawyers who are very much interested in this, to offer some consistency. There is a consistent jurisprudence of the court, coherent, and I may refer, for example, to issues regarding border frontier disputes or maritime delimitation disputes. That's an area where, and given the number of cases, the court has developed an expertise, an experience, and you know that there are decisions addressing issues like the impact of conduct of parties on the delimitation, the title versus conduct of parties. There is a relatively stable rules which have been developed, analyzed, interpreted by the court. And I want to refer in particular in this context to the equitable solution, which is, as you know, included in UNCLOS, in the UN Convention on the Law of the Sea, in Article 83 when it comes to the continental shelf, but also 74 when it refers to the delimitation of the EEZ. And for those who are interested in this notion, the provision in UNCLOS is referring to the need to reach an equitable solution. Of course, at the beginning, I mean, in the 70s, when even before the convention was concluded and entered into force in 94, there were cases brought before jurisdictions, including the ICJ, and at that time, the notion, the expression of equitable solution was not so clear. There was a need to take some decisions in order to reach a precise approach whenever there is a dispute relating thereto. But the court, since quite a number of years now, has developed a method, the three-stage approach, which has been also developed and further amplified in recent cases, a three-stage approach whereby there is a equidistance line which is tested, if possible, if feasible. After that, there is a need to see whether there are any factors calling for another method or the adjustment of this provisional equidistance line. And a third stage whereby the court will assess whether this method and corrections brought to it will lead or not to an equitable or inequitable result. That was more or less codified in the Black Sea case. And what is remarkable is that this method has been adopted by not only the court, of course, but also by other courts like ITLOS. And here in the slide you see a direct reference to this three-stage approach, and also arbitral tribunals. Its contribution, I would say, to really an harmony in international law when it comes to the approach, the method. At the same time, I should also be very prudent. You know that there is not a single method. It depends on the circumstance of each situation, and this three-stage approach, or the first stage, could be put aside if there would be circumstances indicating so. When I use the term codification, I need really to be careful. It's more stability, coherence, a certain level of predictability, but keeping in mind that all depends on circumstances. Every case is a unicum, and also that there is no rule of precedent. You realize that I'm very prudent, but nevertheless, that's a contribution I think we should underline. A second one relates to what I mentioned as efficiency, the possibility to react quickly if there is an urgent request by a party. And here I would like to concentrate on a tool, an efficient tool, which is available before the International Court of Justice. That's the possibility to indicate provisional measures. It's a tool which it is available to parties, but the court may also decide proprio motu. And depending on the urgent character, if the court is seizing itself of it, there will be no even time, depending on the urgency, for a hearing. If you look at the Lagrand case, you will realize that that was a situation which occurred in this particular context. But that's not the point. What I wanted to say is that this tool is available whenever a party is considering that in a particular situation there is a need to indicate provisional measures in order to prevent its rights to disappear. Because if you wait, you may reach a decision on the merits later in 1 year or 2 years if there are preliminary objections, or 3 years. But in the meantime, your rights will disappear concretely. Restitutio in integrum will not be possible anymore. Therefore, you will be compensated, but you will not be able to exercise fully your rights. It's an efficient tool because it enables the court to react with some level of urgency, depending on the situation. The proceedings have priority. This, you put aside what you have and you need to plan a hearing in this context. And of course, there are conditions. It should not be a frivolous request to indicate provisional measures. And the court has also developed an approach, a method, in order to deal with such requests. They are numerous. A number have been submitted to the court, 51, but 15 have been requested, more than that, more than 20 have been requested since 2000. It's a relative recent development, this attraction of parties for provisional measures. Maybe it's because it has the court did clearly affirm that they were binding in the context of the Lagrange decision on the merits. But it is a tool which is used frequently by parties. Therefore, the court was able, through its jurisprudence, to develop conditions, and it's also good for predictability. First, the court should have prima facie competence. That means it's to avoid frivolous claims. It means that the court will have to assess whether later there is some chance for the case to be pursued. In other words, the party bringing this matter should not submit a request to the court simply to get provisional measures. There should be a bit more than that. There should be substance in the claim. I mentioned that because sometimes you will have a unilateral application instituting proceedings and at the same time provisional measures because there is some urgency. The second condition is also that the goal, the object of the measures is to preserve the rights of the parties, but plausibility, that's different. It's not the jurisdiction of the court there. It means that the rights invoked should be plausible. There should be a ground. Also, there is some substance behind that. And it's not whatever rights you may have in mind, that's the rights which are the subject matter of the case on the merits. This is in order to channel those requests to give some guidelines, I would say, to parties whenever they want to submit such a request. And of course, what is important is that what you want to achieve is to prevent irreparable harm. Well, here with the notion of irreparable harm, I need to be cautious in the sense that what is inside is not the responsibility of the parties. It's before that. It's when you want to claim to be able to exercise your right. Because it's not on the side of responsibility when any breach has been noted, stated, found. It's really to ask yourself the question, I will be able to continue exercising my right in this situation or not? For example, there would be an important, urgent risk for the environment of the country concerned. You may wait until the case on the merits, but you will only get compensation. The environment will be damaged. That's important. Or the right you want to achieve has disappeared. You will only be left with compensation, but restitutio in integrum will not be possible. That's a key notion. And the court has a jurisprudence which is very clear and firm of that. Just an example in the case, old case, I would say, the Great Belt between Finland and Denmark, where it was around the building of a bridge over a Danish Strait, and the bridge would have prevented a platform, oil platform built in Finland to have access to the high seas, to the open sea, because the bridge has 8 and the platforms are quite voluminous. Thus it could not go underneath. You could think that if there is no provisional measure ordering the standstill of such construction. That could be the end of your ride, because once the bridge is built, it's difficult to consider as reparation that the party concerned would be ordered to demolish it, to dismantle it. But that's the view adopted by the court in 91. This, if on the merits it is considered that this has to be removed, it will have to be done. And that was the same approach also in the pulp mill case between Argentina and Uruguay. The court took the same approach during the context of the provisional measures instance. That's what is on the screen in front of you in paragraph 70 of the order of 2006. As indicated, one element which may explain why recourse to provisional measures is successful is the fact that in the decision of the court in Lagrange case, the court made it clear that the provisional measures it indicates are binding upon the parties, and that was on the basis of the effet utile, the usefulness character of the provision to preserve it. That's the situation. But I wanted to mention that as a contribution because it's a useful tool for parties whenever they are faced with urgent situation which could prejudice their right and the result of the case. Now, a third point I wanted to mention is, and briefly, that's the issue of human rights, protection of individuals. As you may have realized, the major part of the cases before the court are cases, interstate cases, if you put aside advisory opinions. But it means that you may ask yourself to what extent the protection of persons, individuals, or even companies, legal personalities, may have access before the court. Well, I may reassure you, there is a possibility for a state to bring a claim based on diplomatic protection. And there are a number of cases, the classical one, Barcelona Traction, Inverno, Nottebohm, LZ, more recently, the dialogue case between Guinea and the Democratic Republic of the Congo. It's a possibility for a state to act. That's one category. Now, what about the rule of exhaustion of local remedies? Well, of course, that's a prerequisite when diplomatic protection is used, in the sense that before bringing the case before an international court, the applicant has to make sure that the victim, the person who allegedly has suffered the damage as a result of a breach of international law, has exhausted local remedies before the national court of the state which allegedly is the respondent has committed a breach of international law. That's the rule. Of course, in some instances, the rule will be put aside because it was materially not possible for the individual to exhaust local remedies. That was the case for some claims in the dialogue case, because the person was expelled from the territory of the respondent. But in most instances, when there is a case of diplomatic protection, there is a need to go through this rule and to see whether the conditions have been fulfilled. But I would like to add that the rule doesn't apply in all circumstances where a state is bringing a case involving rights which have been breached in respect of one of its nationals. And I would like to refer to cases involving alleged breach of the Vienna Convention on Consular Relations. That's La Grande case, Avena case, where what was at stake was really a breach of an interstate convention, giving obligations and rights to the parties to it. And therefore, in this particular instance, there is no need to exhaust local remedies, because what is at stake, it's not a state espousing the cause of its national. It's a state acting because of a direct breach of its rights. And that's something which has to be kept in mind, because it, of course, it gives a broader access to international justice to states when rights of individuals are not complied with. Internationally founded rights of individuals. That's one point. Another one, and I refer to a recent decision, that's the decision in November of last year in the case between Ukraine and Russian Federation, where this matter was again raised, exhaustion of local remedies, in the sense that when you look at the Convention on the Elimination of All Forms of Racial Discrimination, of course, it is there to protect individuals. Therefore, is it not necessary for those individuals to first exhaust local remedies before the courts of the state which allegedly has committed a violation? There, the response is in front of you. The response is on the slide. I mean, when there is an alleged pattern of conduct, at that stage, that's more or less the same approach. That's really a breach of an interstate obligation. It's not anymore an individual case which is endorsed, which is taken up by the national state. It's really a breach of the convention as such. It's not an isolated incident. So that's important to keep that in mind, because especially before a court like the International Court of Justice, where only states have been granted access in contentious proceedings, human rights disputes may be considered as something exceptional, but I wanted just to mention that there is also a development in this respect in a jurisprudence. Well, I will try to take, with your indulgence, 10, 12 minutes, 15 minutes maximum, to address the last point, that's the protection of the environment. It's difficult to miss this item, this subject matter, because of the importance of the protection of the environment nowadays in international law. I think that's a very crucial element. And I would say environmental matters have closely or not have accompanied the jurisprudence of the court, and there is probably prospect for environmental cases before the court. So I want to say a few words on that. And of course, as I indicated on Monday, it's in my personal capacity. Corfu Channel case starts the story in a sense when you look at the principles. Of course, the Corfu Channel case is not an environmental case, but what is contained therein and the rule of due diligence, the fact that every state should not let its territory be used in a manner which could harm the territory of other states, right of other states is there. And it's a rule, as you know, which has been included in those declarations which have been adopted in 72 in Stockholm, but in 92 in your country, in the Rio Declaration of 92. That's a cornerstone of environmental law. Therefore, that's important to recall that. In the really first environmental case dealt with by the court, the Gapsikovo-Najimaros project, here also, of course, the case was rather about treaty law, but treaty law in front of a growing concern for environmental matters. And at least the court was able to capture this notion of sustainability, sustainable development. That's there, and sure, it's after Rio, but it gave a judicial shape to this notion. That's something which is important to note. Also in the 1 year before, in 96, there was the legal opinion, the advisory opinion on the legality of the threat or use of nuclear weapons. And there the court stated in its advisory opinion, the environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn. Thus you have such pronouncement. They are not part of the operative part, of course, but it accompanies the development of environmental law, and those paragraphs in judgments or advisory opinions have been celebrated, have been very often quoted. And I would say also that in the past 15 years, 6 cases dealing with environmental matters have been submitted to the court. Currently, there are 2, as I indicated, one concerning the use of common resources, and water course is certainly a subject matter which may lead to future disputes being brought to the court, but 6 cases dealing with protection of species in maritime areas like whaling case, but also in other instances. And to complete my presentation, I would like to refer to 2 cases. Of course, pulp mills, one of those 6 cases, when it was about harmful impact, allegedly, for Argentina, of pulp mills built on the territory of Uruguay, but close to the river border. And it's important, this case is extremely important for the development of environmental law, because through its decision, the court was able to affirm a number of principles. I will simply limit myself to the principle according to which there is an obligation for every state to undertake an environmental impact assessment. It's one of those procedural obligations or rights which are very important, crucial, in order to ensure that the environment is protected. Sure, the key elements are not mentioned in international law, what should be contained in an environmental impact assessment, but the court also mentioned that it's part of the duty of vigilance and prevention, the due diligence obligation. Thus, you cannot make an environmental impact assessment which is an empty shell. You need to give substance to it, and that could be assessed by a judge later. But that's a requirement, that's customary law. That's something which has to be undertaken by every country. That's very important. And sure, on the question of precautionary approach or principle, The court didn't pronounce itself, but at least mentioned that it may be relevant in the interpretation and application of the provisions. The statute is not the statute of the ICJ, I may reassure you. That was the treaty instituting a commission, the Caru Commission between Argentina and Uruguay. Because in order to interpret the treaty at stake in this case, you may use a precautionary approach if it's needed for the purpose of interpretation according to Article 31 of the Vienna Convention. Because that's, at least it's another step towards the recognition step by step up of the precautionary approach. Now, to conclude, and I mean it, that's really the last case I wanted to see with you. That's the latest decision, I would say, regarding environmental matters. That's the case between Costa Rica and Nicaragua. And it concerns, in the latest phase, the last phase of this case, the decision of the court on reparation, compensation for environmental damage. Because it was really expected by the international community, and you know that the damage to the environment as such, as a notion which is distinct from damage to property, injury to persons. I mean, what can be assessed through an economic approach? If, for example, there is timber damage, you know that you can sell this particular wood and it has a price on the market. This you may assess to a certain extent the damage to the environment. But what happens when it's pure nature or marine environment with species which is not in trade? You cannot trade them. Because that's important. And of course, the international law adds already some decisions which were rendered in this matter, and you may think of the decision or reports adopted by the Compensation Commission, which was instituted after the first Gulf War between Kuwait and Iraq and Kuwait. There were already some pronouncements, findings, but it was the real first time that the international court and an international court had to deal with the notion of environmental damage. And in this respect, I would say there were a couple of very important pronouncements made by the court. First, on the side of evidence, the court, and that's the result of a tradition, the legal tradition, referred to a celebrated decision in the law of protection of the environment, in international environmental law, that's the trail smelter arbitration, where the arbitrators in this specific decision made it clear that when you need to assess the amount of damage, you don't need necessarily to assess this amount with precision or too high precision. When the damage is certain, there was damage, and it has a certain amplitude, it's important, there should be an award of compensation. The fact that you cannot identify precisely the amount or with sufficient precision should not preclude the court of entering into the issue of compensation. That's important to keep this principle in mind. A second one is that the court was also using building blocks which have been developed in the international environmental law. It means that when you have to face damage to the environment, there are different steps or different elements to keep in mind. First, you have the restoration costs, primary restoration. You need to clear the ground, take revegetation measure, reintroduce species. That's the primary restoration, and it's, in a sense, what is disclosed in paragraph 43 of the judgment. You cannot just wait 20 years for the nature to cure itself. You need to take some steps. In this particular instance, it was a very limited amount granted by the court, but it was there. And from the symbolic point of view, it's very important that this part is there. Also, there is the compensation for loss of the ability of the environment to provide goods. That's the compensatory restoration in international environmental law. That's the loss of the use. And that was very carefully assessed in the decision of the court. And there was an amount also granted to the parties. Compare with other decisions, I refer to the UNCCC, Compensation Commission of United Nations. There, any award of compensation for compensatory restoration is not simply given back. It has to be used for actual project. But in this particular case, I would say there was no need to enter into this logic probably, but that's my own assessment. I wasn't there, and even if I would have been there, there is a secrecy of confidentiality of deliberations, but the amount involved was relatively small. There was no need to put into place some monitoring plan. I mentioned those two elements. There is a third one, which is also contained in the decision. It's the reimbursement of costs which are incurred to monitor the damage, to prevent an increase in the amount of damage. And those measures traditionally in environmental law have to be dealt with, have to be reimbursed. And the court also addressed that. Those were, for example, the fact that Costa Rica had to lease the services of a satellite to monitor the region, or there was a need to overfly the region to see to what extent armed forces were still there in the disputed territory. Those were also valid costs. But I think that's a very important pronouncement, because after having considered that the rule is breached, you need to go to responsibility, to issues of compensation, valuation of damage. And I would say the court was courageous enough to cross that bridge and to address frontally those issues. Because that concludes my overview of what I would say elements or issues, items on which the court made a contribution. Well, that concludes my presentation, and thank you very much for your kind attention.
Thank you very much, Professor. Thank you very much for such an interesting and provocative vision and conference, especially for guiding us to the history of the court, but also for the future of the court, to the next 75 years of the court. Thank you very much. So we already have here some questions. I would propose to Professor Gautier a round of 3 questions, if you don't mind, okay? I would start with a question from Fernando Porto de Sá, saying that, Professor, should the ICJ be more aware of developments in regional international law, in especially the Inter-American Court? As an example, I think of its divisory opinion on consular rights taken before the Avena and Lagrand cases. The second question comes from Igor de Holanda, Professor Gautier. You mentioned the efficiency of the court. What could be done to decrease the time spent on a case? Most of them take several years to be concluded. And the third question, I mixed two similar questions from Gustavo Leite Neves da Luz and Letícia Maciel. They ask, Professor, from your practice experience, what would you say that are the main distinctions between the proceedings and the deliberations of the ICJ and the ITLOs? Have you perceived any difference in relation to the culture or to the legal training of the judges, for example?
Okay, no, thank you. Thank you for those questions and for your kind comments, Professor Macio Franca. I will respond to those questions one by one, of course. I will start with the first one. It's a very interesting question because you may answer to that from different perspectives or taking different approaches. To be aware, I'm sure that like all international lawyers, if you want to keep abreast with what's going on in international law, you need to follow the work of international courts. Of course, you will speak to someone convinced, because I already told you that without international courts, the international law cannot really develop, grow. I am really convinced. That being said, to be aware, what does it mean exactly? You know that the court is the principal judicial organ of the UN. It is an independent court. Therefore, you cannot appear as being influenced by other international courts, or whether it's worldwide or regional. There is always a cross-fertilization to a certain extent among international lawyers, and judges may also participate in symposia. There is a judge from Brazil, Judge Cansado Trindade. There's, of course, that there are some influences which, and that's good to come from different regions, countries, and also as lawyer, as I told you, if there is an advisory opinion which is very important on environmental matters rendered by the Inter-American Court of Justice, you know, it's through the grapevine. There will be articles on that. One thing is to be part of this international community, and you cannot operate just reading decisions of the ICJ only, I would say, but that's my own position. But you need to know, you cannot function in splendid isolation. And when I say that, I'm referring to a pronouncement of the panel, the appellate body of the World Trade Organization. That's what they say, even if their jurisdiction is very much confined. But that's when you say that, you already mentioned that you are not isolated. That's one thing, but on the other hand, you cannot, I would say it's difficult to refer to that, to a decision, for example, of another court, if, for example, it's not the basis of an argument developed before an international court by one of the parties, for example. But even that, there is no precedent. There is no rule of precedent before international court. Therefore, it's more part of the good practice, cross-fertilization committee among international courts. Let's take the example of the three-stage approach. The court has no hierarchy above other arbitral tribunals or ITLOs, but since it was such a elaborate, well thought of, reasonable approach, it has gained consensus. That's a way of that's the way the process would evolve, I would say. I don't know whether I fully respond to the question, but I think that's my way of addressing the question. Regarding the time, I thank you for addressing this question. I should have addressed that because it's true that if you look at the number of years a case is taking, it's considerable. Even if the court wants to accelerate proceedings to a certain extent with the number, with 15 cases now. If there are 3-4 cases dealt with per year, that will take some time. It's well understood. No, I want to say two things. The first is that and it's not to say it's not the court, that's the parties. That's not at all the intention. It's simply to say that if you look at those cases, those proceedings, most of the time is taken by the parties. If you look at the hearing, and after the hearing, it's taking 6 months. It can take 10 months, but normally no more than 6 months. After the hearing on the merits and the decision. This is relatively reasonable. But on the other hand, as I indicated to you, with the increase in number of cases, with the fact that most of the cases are the result of unilateral application, and rightly so, it's on the basis of the consent given in advance. But you will very often have preliminary objections, plus 2 years, if everything goes well. Thus you will have some incidents which will, in a sense, delay the process, but because parties want to make use of all arguments, because cases are important. But of course, if you have a special agreement, and through the special agreement, the parties have agreed to submit pleadings every 5 months, you will have a decision in less than 2 years. Because that's something which should be kept in mind. What I wanted to say, addressing the issue of provisional measures, is that there is a tool which may be used, and it's not because the case is going on for a number of years that parties are deprived of efficient tool in order to avoid that their rights would fade away. That was my intention, but I recognize that there is a number of years for cases to be dealt with. Now, the last part of the last question. Well, I partly answered that on Monday. Sure, I will not make any comment on what is the judge's background, except that I would say to be a judge at ITLOS, in principle, the specialty is law of the sea. And that's the reason the tribunal was instituted. It was because it was considered that in light of the number of cases involving law of the sea issues, there was a need to have a specialized court, and therefore judges there should have this specialization. That being said, before the court, even if judges would be experts in international law, and that's part of the qualification. You may look at the statute. I show you the article on Monday. By the nature of cases submitted to the court, judges will get more exposed to some matters, including delimitation of maritime boundaries. In a sense, there are more cases dealing with maritime boundaries before the court than before it lasts, but there are other cases before it lasts. That's what I wanted to say. For procedure, I mentioned that there is a huge difference because there may be private individuals before the chamber for the settlement of disputes relating to the seabed area. There are also specific procedures which have been developed on the basis of the convention, prompt release proceedings, also provisional measures pending the constitution of an arbitral tribunal. There are specific features which have been successful before it lost, but which are not similar to exactly what is applicable before the court in terms of procedural rules. I alluded to also the difference in some aspects like time limits to file preliminary objections, things like that. Also in the internal functioning of the court, the fact that judges here have to draft a note to explain their position at the beginning of the deliberations. Of course, it may evolve, but that's something which is not a common feature before the tribunal. The fact also that here judges are more on a permanent basis in The Hague, therefore cases are planned in a different way. In Hamburg, judges are not permanently there. The president is there, and therefore judges are meeting at specific period of time to discuss cases. It's another approach, but
Mercosur court.
Yeah, that's what I would say as an answer.
Let me ask just another question. Could you make a short comment about the impact of the COVID pandemic and the works of the ICJ? How and if and how the pandemic affected the work of the ICJ?
Yeah, thank you. Yes, it affects, of course, like all of us. And when we say to someone, stay well or good health, it means really something. Not that before it didn't, but there is another consonance, another impact. Now, regarding the court, we had to adjust to the pandemic situation in Europe, more precisely, but not only in Europe, but first in Europe because there are 120 staff members and 15 judges and judges ad hoc also who may come. Thus we had to adopt measures in order to ensure that on the one hand we would protect all staff members and judges, of course, but also we would be able to continue functioning. Thus if you consult the website of the court, you will see there were some press releases issued on that matter. Official visits were stopped, things like that. But we rapidly, I would say, and with the assistance of colleagues, we were able to move to teleworking, video working. This teleworking is something which is common now with the registry. That was the first phase, and we had a couple of weeks to avoid stopping working. I mean, the court cannot stop. Therefore, deliberations are going on. There are judicial meetings. There are steps which were taken in order to ensure first that there could be a possibility to organize meetings in distance through video link, and also to organize hearing in distance. And there was a one-day hearing in the case instituted between Guyana and Venezuela, and that took place. That was quite successful, but that was quite an experience to put that into place. And there were 2 judgments rendered last week, 14th of July, in the ICAO cases. That was also with the participation of some judges and also participation of judges through video link. And parties were represented in the Great Hall of Justice. There were 5 states represented, but with confinement measures. Sure, it has caused a certain delay, but now we can operate, and I would say after 3 weeks, the delay was limited to 3-4 weeks. After that, we were able to resume, continue activities. It has an impact. It's not the same, and it's not a secret. I will not name the parties concerned, but in September we should have also hearings. That's if you consult the internet and the website of the court, there will be, I'm sure, press releases in the coming weeks in this respect.
Okay, very good. So, Professor Gautier, I think it's time to conclude our session. Once again, thank you very much for your availability, your participation, your conference. In my name, in my personal name, it was a pleasure and an honor listen to you in this opportunity. I don't know if you want to add some final remark, final words.
No, thank you, Professor Macio Franca. I really appreciated this invitation and our interaction. It was very good to have you, and I wish to thank also your students and those who join. It's a bit frustration, some kind of frustration not to see from time to time
yes.
a reaction, some concerns in the eye of participants, and that indicates to you.
Next time, personally, I hope in Belo Horizonte or elsewhere in Brazil, certainly it will be better.
But it was a wonderful experience, and it's great from the CEDIN and the University of
Minas Gerais, Belo Horizonte,
to engage in such a program, and I wish you well for the coming days. Bye-bye.
Bye-bye. Thank you very much. Bye-bye.
My pleasure. Bye-bye.
My pleasure. Bye.